Without any further ado, to make sure we get as much chance to listen to our wonderful panelists and moderator as possible, I'll turn things over to our moderator, who is also the sponsor for tonight's event in terms of providing us with the copies of the book and also the wonderful reception we have planned for you all after the substantive event. So without any further ado, Mr. Paul Williams.
Great. Thanks, Wes. I appreciate that. There's a couple of chairs up front and over to the side. If there's anyone that's still standing in the back, now is a really good time while I'm talking to walk up to the front and sit down before we turn it over to Mike and Sean. As we begin, we're very excited about this panel discussion today because many of us, all of us, at one time were second-year law students. We took public international law. We learned about customary international law, state practice, opinion juris, blah, blah. And it wasn't very exciting that one day we learned about customary international law. But there seems to be a reevaluation, another look at customary international law. People have talked about instant customary international law. They've talked about sort of spontaneous moments. Professor Scharf is putting the concept of Grotian moments into the debate, and Sean has also done a lot of work on the traditional customary international law, as well as teasing out some of these developments to try to push it forward, make it a little more spontaneous, make it a little more applicable to the rapidly changing world. So before we get into our discussion today, I wanted to do two things. One was to give a shout out, and the other one was to tell a little story. I want to give a shout out to Ed Williamson, who was the legal advisor at the State Department, who hired me and took me away from water law and put me on the path of public international law. So I'm going to be very careful about what I say about public international law this evening, since Ed was my mentor. And also thanks to Ed, I got to know Michael Scharf and Sean Murphy. I showed up at the Department of State in 1990, and I was put on the European desk doing legal work. I had no idea what I was doing. I went to my first meeting, and I said, I'm working on Yugoslavia. And they said, oh, well, given all the conflict, you have to go, talk to Sean Murphy. You have to get the work that you're doing cleared by him. I said, great. Who's Sean Murphy? And they said, he's the wicked smart one. And I said, well, that's helpful. But where do I find Sean? But that was Sean's reputation around L. I'm embarrassing you now. That essentially he was the wicked smart one. He was the one who was able to get
what I am.
And Sean was the one who could get his head around these new, innovative, complex legal issues that were coming to the State Department after, former Soviet Union, 90 years of the Cold War, nothing interesting happened on the EUR desk. And all of a sudden, Yugoslavia, Soviet Union were falling apart, lots of complex legal issues. So I beelined it to Sean and got him to help get me on the right path. And so hopefully this evening in the next hour-long discussion, he'll help enlighten you all as well on customary international law. I'll use the microphone, haven't learned that after all these years. And so I'm sitting in my office, I'm enlightened by Sean, I'm getting focused, and Mike comes stumbling in with 2 pieces of pizza and a paper rolled up under his arm. And he sits down and he hands me a piece of pepperoni pizza, and then he unravels his piece of paper and he says, right, I was told I needed to get your clearance on this. And I said, great, what is it? UN Security Council resolution dealing with Yugoslavia. And we sat there over a couple of pieces of pizza and marked up a UN Security Council resolution on Yugoslavia. And that's when Mike and I began to become fast friends. And ever since then, we've collaborated on a number of projects, research projects, as well as some practical work on public international law. So I'm very excited that Michael and Sean will be able to spend the next hour answering a few of my questions and then answering many of your questions. You all have the formal bio. I've given you the informal introduction. Sean holds the research professorship at George Washington University here in town, and he's also a member of the International Law Commission, where he is shaping the development of law, including customary international law. And Michael is the chaired professor at Case Western University and is also the managing director of the Public International Law and Policy Group. So I will have those brief introductions, and now I will launch into my first question. It just so happens that Professor Scharf has written a book on customary international law and recognizing Grotian moments. So let's just start with 2 or 3 minutes, Michael, about this notion of a Grotian moment, why you wrote the book, and what you're hoping to accomplish with that.
Okay, happy to. I should say before I begin, I did a presentation for the PILPG Fellows while I was in town, and they said, we hear that you are the Steve Wozniak to Paul's Steve Jobs. What's Wozniak's first name?
That would be it.
Yeah, and I'm like, what, man, this is why you have this stumbling in and all that. I see it now. Okay, anyway, the story for me begins in 2008 when I was on sabbatical, and I went to the Cambodia Tribunal to be the special assistant to Robert Petit, the chief international prosecutor, for 4 months. And while there, he put me in charge of writing the brief in response to the defense motion to exclude joint criminal enterprise liability from the jurisdiction of the court. Now, for those of you who don't know what JCE is, that's what they call this, the defense call it just convict everyone, but it's basically like the felony murder rule or the Pinkerton rule in American criminal law. It's a very broad concept of responsibility. And all of the international tribunals today, since the Tadic case in 1998, have been applying this. So the Yugoslavia Tribunal, the Rwanda Tribunal, Special Court for Sierra Leone, Cambodia Tribunal, they all apply it. The problem for the Cambodia Tribunal was that they could only apply things that occurred, that were law, at the time when the crimes of the Khmer Rouge were occurring. So 1975 to 1979. And the only precedent for JCE that potentially existed was Nuremberg, the Control Council Law Number 10 trials, and the General Assembly resolution endorsing the Nuremberg principles, but not specifying what those principles are. So the question in the brief was Nuremberg a moment that only took a year that actually was a paradigm shift that radically changed customary international law, such that with this small little precedent, much smaller than what you normally see in terms of the slow crystallization of law over many years and many habitual state practices. This is just 1 year. Could it have created customary international law? And we argued that it was a Grotian moment, and this had been a term that Richard Falk had coined in 1985, and we applied it to the brief, and the court accepted it. And so now all the courts of the international tribunals are applying this, and they accepted that Nuremberg was in fact a moment where there was rapid formation of customary international law. Now that got me thinking, are there other times in the last 60 years since World War II where there have been similar situations where customary international law forms within about 10 years, which would be super fast? And that's the parameters that I set artificially for what is a Grotian moment. So I sat down with Chris Greenwood, the UK judge in the International Court of Justice, 2 years ago on my birthday when I happened to be visiting in The Hague, and he took me out for a nice dinner, and I talked to him about this issue. And of course, Chris Greenwood is super brilliant. So he said, yes, of course, Michael, I could name many of these situations, and he started reeling them off. So he talked about, in addition to Nuremberg, the Continental Shelf Proclamation by Truman. He talked about the advent of space law. He talked about the Tadic decision, not in terms of joint criminal enterprise, but of applying all or much of international legal responsibility that used to only apply in international armed conflicts to domestic internal armed conflicts, civil wars. And then he said, and there's two that may or may not fit your model, and you should explore them. One is the 1999 NATO intervention and the responsibility to protect doctrine, and the second is the targeted killing of terrorists, basically attacking non-state actors in third countries on the argument that the country was not responsible for their acts, but failed to control them or was unwilling to do anything about them. So those became the 6 case studies that I explore in this book, looking at whether there is such a thing as accelerated formation of customary international law. Can there be new paradigms, new international law rules that develop super fast within 10 years? And while I was writing the book, and I'll end on this, I was invited to visit the Kiyosora Corporation in Kyoto, Japan, because Mr. Inamori, who runs that, is the patron of the university at Case Western Reserve University's Inamori Center for Ethics and Excellence. So I was there, and he was showing me around this museum, and he said, and here we have all of our recrystallized gemstones. And he said, unlike regular crystallization that takes millions of years, we can do this in about a month with intense heat and pressure. And I said, that's the analogy. That's what's going on with customary international law during a Grotian moment. And so I wanted to look to see, when does that happen? When do you have fundamental change in the international community, be it by new technology or geopolitical realignment or massive war or terrorism or crimes against humanity, that basically ignites or serves as an accelerant to customary international law? And the theory then is that customary international law is not simply a matter of counting the number of states and the practice and looking at a long term of time, but rather it's the context in which those arise in, that there's a third factor that can be really important to the formation of speedy custom. And this isn't instant custom, but it's fast. Defined as 10 years. So that's what the book's about.
Great, thanks, Michael. Sean, you're currently on the International Law Commission at the UN, and the question of customary international law, its formation and its evidence has been put to the Commission. Can you give us a little bit of background on how the Commission is approaching this question and whether or not they'll possibly be addressing this accelerated customary international law?
Sure. Well, thank you, Paul, for the question, for your introduction. Thank you for the invitation to be here tonight. The International Law Commission did decide in 2012 to take up the topic of formation and evidence of customary international law, and it appointed Special Rapporteur Michael Wood, the UK member of the International Law Commission, to be the center piece of that project. So Sir Michael, from 2012 to 2013, worked on and completed his first report on the topic, and that came out this past May. So in this past summer, the Commission discussed that report, which was very well received, and he'll be going forward with it from there. I should note that a very important person who's been assisting Sir Michael is here tonight. Omri Sender, sitting in the corner in this room, is an instrumental part in helping Sir Michael with this topic, and I'm glad he's here and taking probably at least mental, if not handwritten notes. The first report basically ran through the Commission's prior work on the topic of customary international law and the type of terminology that's used with respect to this particular source. It also basically affirmed the idea that the twin elements of state practice and opinio juris continue to be the sort of relevant building blocks for it, and does a superb survey of the scholarship in the field. So if you're looking for a really good sort of background report on customary international law, the first report that came out in May will be of some interest to you. I should note that the Commission this summer decided to change the name of the topic. Instead of calling it Formation and Evidence of Customary International Law, we are now calling it Identification of Customary International Law. And there's a little bit of an interesting backstory on that change, but I'll leave that for now. In terms of what we're planning to do with it, first of all, I would say it's a little bit interesting that the International Law Commission, 60 years after its formation, is only now getting around to attempting to talk about customary international law as a field. You know, it is one of the main sources of international law. In any event, it has embarked on this, and Sir Michael's intention is to do a series of conclusions with commentaries. So these will not be draft articles that are intended to become a treaty. Instead, it'll be a series of conclusions backed up by commentary. If you're familiar with the project that was done by the International Law Association that came to fruition in 2000, I suspect that the ILC's project will look something like that. So the International Law Association, this global body of international lawyers, non-governmental, produced in 2000 a statement of principles on the formation of customary international law. It's 33 principles with associated commentary that comes to about 66 pages. So I suspect the ILC will end up doing something like that. Knowing Sir Michael, it's going to be shorter than that. Not quite that many principles, not quite that many pages. On the other hand, he's got to convince the commission that, you know, he's got it right. So who knows where we'll quite end up with it. So I think that's what's going to come out of it. He'll do his second report for next summer, 2014. That's going to look more deeply at those twin elements of practice and opinio juris. It's also going to be looking at the effects of treaties on customary international law and the relationship of decisions by international organizations to international law. The third report will come out in 2015. It's going to look at some particular aspects of the subject, so the persistent objector rule is going to be probably in that report, the concept of regional custom, and maybe of even bilateral custom, as we saw in the rights of passage case. And then the fourth and final report is supposed to come out in 2016, laying out the final principles. So the idea is to finish this up in this quinquennium, meaning the 5-year period of the current International Law Commission. It may be an ambitious schedule, but that's the one that Sir Michael is currently pressing for. Will we take into account the temporal element? Absolutely, right? I think that certainly is one part that's always been of interest to those studying the field of customary international law. So no doubt we will learn from Michael's book and other writings on this topic.
Great. Thank you, Sean. Turning back to Michael, on the back of your book, Jose Alvarez, who's the co-editor of the American Journal of International Law, sponsored by ASIL, comments, "This is not a safe book. Virtually everything that Scharf argues is contestable. His premise that customary international law remains important in an age of treaties, his contention that there's a third element of customary international law, etc., etc., etc." So, 2 questions for you, Michael. Why did you put this on the back of your book? And secondly, do you agree that it's contestable in the age of treaties?
You know, Jose is a good friend, and he did us a good favor by being provocative, because when you read this, you're going to want to read the book. And it's always, you know, the old statement that even, you know, bad press is good, any press is good press. But I think ultimately, you know, he concludes in the last sentence that with this book, Scharf becomes a custom pioneer of a different kind from the states and institutions that he addresses, and that this is a book that everybody needs to read. So I'm very grateful to Jose. The interesting thing that he says here is that he seems to assume that nobody believes customary international law is important anymore, notwithstanding that the ILC is studying the heck out of it for the next 5 years. He seems to be of the view that in an age of treaty where everything has been codified by the ILC for so many years and all these treaties, there's just not much custom left. And so there's a part in the book where I start out by at least saying why custom is still important. I think there's actually 4 reasons why custom is still important and sometimes more important than treaties. And for those of you who are, you know, starting out taking international law, this is useful information. So the first thing is that customary international law applies even to non-parties, whereas treaties only apply to people who ratify, where the advice and consent in the US is given to a treaty. Custom can apply to all the countries in the world except for those who are persistent objectors. And so it has a much broader application. The second thing is when there are treaties, like the Law of the Sea Treaty and others that are taking a long time to ratify and even longer to bring into force, the treaty itself can become custom and can bind countries before the treaty's in force and can bind countries that are not party to the treaty. The third thing is most treaties today have an escape clause where you give 6 months notice or a year notice and you can withdraw from the treaty. Customary international law you can't withdraw from. Until the custom changes, you're stuck in it. And then the final thing, and this is the part that gets right back to my thesis, most people think that treaty law is faster than customary international law. But there have been a lot of treaties in the last 50 years that have taken 25 or 30 years from start to finish. So the Law of the Sea Treaty, the International Criminal Court, the Vienna Convention on the Law of Treaties, these are treaties that have taken decades to complete. Custom sometimes under the right circumstances, can arise very quickly. And so for those 4 reasons, continues to be a very important part of international law and is worth the ILC's time and my time in writing about it.
Okay, Sean, you in the Jose Alvarez camp or the Michael Scharf camp on this one? Or is there a Murphy camp?
Maybe there's a Murphy camp somewhere. I guess I'll say I'm in the Michael Scharf camp. It is natural for us, I think, to sort of intuitively think that treaties have become the much more dominant source of international law. And certainly, relatively speaking, that's right. 200 or 300 years ago, certainly custom dominated relatively few treaties. Today, lots more treaties, a lot more ways in which maybe you would have a treaty relevant to a particular issue or dispute. But it's a big mistake to think that treaties are the only game in town. And let me, maybe second Michael's remarks by taking a look at the 2012 jurisprudence of the ICJ as just sort of a little snapshot as to whether we think customer treaties dominate. In the 2012 calendar year of the ICJ, there were 4 major contentious cases. Of those 4 contentious cases, 3 of them turn on customary international law, not on treaty law, right? So many of you are probably aware of the Germany-Italy case, where the issue is Italian courts had proceeded to allow certain actions, civil actions against the government of Germany relating to Holocaust-era claims, or World War II-era claims, I should say, various atrocities committed by the German military in Italy, Italian claimants trying to seek redress for that. And the question ends up being, is it okay to allow those claims to go forward in the national courts? Germany says no. Germany says we're entitled to immunity under international law, and they take the case to the ICJ. There's no treaty between Italy and Germany on state immunity, right? There is a European Convention on state immunity. Germany's a party, Italy isn't. There is a UN Convention on state immunity. Neither state's a party. It's not even in force, right? So the whole case is all about what's customary international law got to say about the immunity of states in that particular kind of context. And the court ends up concluding that Germany did have immunity in Italian courts. Second decision, the Amadou Sadeo Diallo case, right? Which is at the reparations phase. The court had previously decided that there had been a violation by the Democratic Republic of the Congo of 2 treaty provisions, one relating to the ICCPR and one relating to the African Charter on human and people's rights. But at this point in the process, the question is, what is the appropriate type of remedy to be provided for that violation? The treaties don't answer that question. Right? The treaties don't say, by the way, if we're violated, the following types of remedies are permissible, right? Instead, the court basically has to turn to customary international law to try to figure out what are the proper heads of damage, right? Material, non-material, moral, whatever. What's the nature and quantification of non-material injury? Whether compensation can be awarded for things like lost income, whether post-judgment interest is appropriate. The treaties, there's no treaty between the 2 states that answer those questions. So the court has to survey case law and precedents and whatever they can grab a hold of to reach conclusions about what customary international law says in that instance. The third case, territorial and maritime dispute case, this one between Colombia and Nicaragua, right? Here's a case where you might say, well, surely the Law of the Sea Treaty applies. Well, as it turns out, Colombia is not a party to the Law of the Sea Convention, right? So when you get to the point of having to figure out what's the appropriate way to delimit the maritime boundary, it's all customary international law, right? Now, that's not to say that the court's only interested in customary international law. There was a 4th major case, the case involving Belgium and Senegal, obligation to prosecute or extradite. That case does center on the Convention Against Torture, which was enforced between the 2 states. So I would say, when you've got a treaty in play, the court and others are going to gravitate to it. But it's absolutely right that in many instances, there simply isn't a treaty relevant to the issue. And I'm just taking that snapshot of 2012. But you could expand that to other years of ICJ jurisprudence, and you could expand it to other disputes, not just before international courts and tribunals, but between states. And there often simply won't be a treaty regime in place. The discourse is going to turn on the states' respective arguments with respect to customary international law. So I guess I'll put myself in the Scharf camp.
Great. My next question is going to take about 30 seconds to ask. So those of you in the back, we've got about 10 seats over here on the upper left if you want to walk while I talk very slowly. Come on in. You might as well sit up front. Great. Okay, Michael, the premise of your book is that fundamental technological, social, geopolitical change can accelerate this formation of customary international law. Other than your tour of the facility where they made recrystallized gemstones, what is your evidence for this thesis?
All right, so I mentioned earlier the book explores 6 case studies, and ultimately the conclusion is that the first 4 do prove the Grotian Moments phenomenon, and the later 2 are interesting for showing the contours of the phenomenon, but they did not ripen to Grotian Moments. But to just go through them, Nuremberg, prior to 1945, the law was what a country did to its own people was its own business. Nuremberg, the first international trial, created a lot of new rules of customary international law. There wasn't another Nuremberg-like tribunal for 60 years. And yet, when the tribunals were created, they all recognized, and a lot of domestic courts have also recognized, that the principles that came out of Nuremberg, principles like you can't use the obedience to orders defense when you commit a war crime or a crime against humanity if it was manifestly unlawful. The principles like the joint criminal enterprise form of liability, those have been recognized as coming out of really a very short period of time. This novel Nuremberg tribunal that it arose out of the worst atrocity ever, the Holocaust. And it arose out of the unique situation of the end of World War II. Now, the continental shelf is another really good example. Before Truman's proclamation, the rules governing the continental shelf was that everybody had about a 3 nautical mile territorial sea, and everything else was it was fair game. It was the high seas, and what was under it, anybody could have access to. Truman, at the end of World War II, said the 200 nautical mile area off our shore that's shallow, mostly in the Gulf of Mexico, we claim the right to the minerals that are under there. And immediately after that, most of the coastal states made similar proclamations, and within 5 years, just about everybody was recognizing that this new concept had overtaken the old law of the sea. And then finally that was enshrined in an International Court of Justice decision. Then you've got space law. In the context of space law, there was new technology. Rockets were flying up over the countries in the world. They were sending satellites, and they were exploring various bodies throughout the solar system. The rules for space law could have been the same as the law of the sea, and territorial law. It could have been that if you have a spaceship that flies over another country's territory, you have to get their permission. And if you put a satellite geosynchronously over their territory, you have to pay a license or get their permission to do so. And if your astronaut lands on their territory, it's like Gary Powers in the U-2 crisis. The other country can grab them and say, you're a spy, you're an enemy, you have no right to be in our territory. But when the Soviets and the US started sending off the space flights, they wanted a new paradigm, and they didn't have time to create a treaty, so they created a new body in the UN, the Outer Space Committee. It created a resolution, and almost everybody agreed very quickly that the principles in that resolution had very quickly become customary international law. And those principles were such that you could fly over other countries, and the astronauts were treated as ambassadors of mankind. And you didn't have to pay a fee when you put your satellite in geosynchronous orbit. The fourth one is the Tadic case, and in that case, the Yugoslavia Tribunal, again, this comes in an interesting point in history where the Soviet Union had collapsed. The Security Council was now able to create new tribunals and pass resolutions because it was free from its Cold War paralysis. Genocide had come back to Europe for the first time since World War II. And this tribunal, in its appeals decision, said for the first time ever that individual criminal responsibility that normally applied in international armed conflicts also applied in internal armed conflicts. And immediately after that, many countries around the world changed their guidelines for their soldiers. And then when the International Criminal Court statute came about, 2 years later, they enshrined it in the ICC statute. 122 countries have ratified that. And the US and Russia and China, which haven't ratified, have acknowledged the principle because they have sent situations involving criminal responsibility for internal armed conflict to the ICC through the Security Council mechanism, and I'm talking, of course, about Libya. Now, the two outliers, maybe I should save those for later, or should we
Let's go ahead and
start
take
to
those
talk
for
about
later.
it? Okay, well, so
We want to put that to the test now with Sean.
right. Okay, so those were the four examples that I thought proved that you do have rapidly formed customary international law in these times of radical change. And there are probably others. There's probably, the advent of nuclear weapons, the advent of the internet. There are other changes we could have looked at which may or may not have become customary international law, but would have been interesting candidates to explore. But those were the ones we explored.
Great. Yeah. Thanks, Michael. Sean, do you agree with Michael that customary international law can form rapidly under certain circumstances, and do these 4 case studies support that thesis?
I do agree with him. I do think the case studies are good ones that support the proposition. I suppose I will put myself not in the Michael Scharf camp on this one, simply because I don't think this is a new proposition. I think this is something we've known for quite some time, right? And so one way to demonstrate that is to talk about the North Sea continental shelf cases, right? In 1958, we do have a convention on the continental shelf that's developed, but a lot of states don't join it, and it only enters into force a few years, 5 years later or whatever. And in the North Sea continental shelf cases, you have a situation where Germany's not a party to that treaty, and we're all talking about at the court, is it the case that a particular rule, the equidistance method of delimiting a continental shelf, has passed into customary international law? And the court says in a very often quoted passage, they say, although the passage of only a short period of time is not necessarily of itself a bar to the formation of a new rule of customary international law. So they're sort of recognizing that the passage of only a short time doesn't prevent formation of customary international law. They then say an indispensable requirement would be that within the period in question, short though it might be, state practice, including that of states whose interests are specially affected, should have been both extensive and virtually uniform in the sense of the rule that's being invoked, right? So this is happening in the shadow of a treaty in that particular context, but I read the court as talking about this more broadly, that it is possible in a fairly short period of time, the period of time there from 1958, because as of 1958, everybody agrees this rule is not a part of customary international law, to 1969, which is when the court decides the case. In that decade, the court is basically accepting the proposition that a rule of customary international law could form, right? So cases like that were looked at and studied and talked about, throughout the decades following that decision. And I mentioned the 2000 International Law Association study on customary international law. They, in their Principle 12, say, although normally some time will elapse before there is sufficient practice to satisfy these criteria, meaning a criteria of uniform, extensive, representative practice, no precise amount of time is required. Okay? So this is the International Law Association in 2000 kind of looking back on cases like North Sea and others and basically saying normally some time will elapse but no precise amount of time is required. And they then talk about that They say there's no specific time requirement. It's all a question of accumulating a practice of sufficient density in terms of uniformity, extent, representativeness. Some customary rules have sprung up quite quickly. For instance, sovereignty over airspace and the regime of the continental shelf, because a substantial and representative quantity of state practice grew up rather rapidly in response to a new situation. And then they go on to talk about President Truman in the 1945 declaration. So I do agree that this is possible, but I guess I'm not convinced that up until this point we had thought you needed 40 or 50 years or whatever the predicate would be for saying actually it's 10 years or so. So I think Michael's book is a wonderful collection of case studies, some of which say custom is formed over 10 years, some say no. And I think in that sense it's a fabulous book to read. But if the premise is we didn't know this before, I'm not in agreement with that.
Okay.
Mike,
So-
old wine, new bottle?
Yeah.
Response?
We probably did not know this before the International Court of Justice's decision, because prior to that, you have statements, which I've quoted in the book, by the United States, Germany, the UK, France, the International Law Commission, that suggest that decades are necessary. Sometimes they say at least 3 decades. One says at least 40 years. The ILC said it takes a considerable amount of time. So prior to the ICJ's dicta in that case, that was the concept. Now, since the ICJ's dicta, nobody has really looked at how fast can this happen and what are the criteria that allows the rapid formation. And that's really what I'm trying to do in the book. Ultimately, the question, I guess, is, are we talking about paradigm shifts or tipping points? You can think about that. Tipping points would mean that there have been accumulations, and it's just the moment where you get enough. And you can say, well, this book is just focusing on that one moment, and that's not fair. At least with Nuremberg and with some of the others, I think we're talking about paradigm shifts. I think we're talking about situations where there really is very scant state practice and very short time, and it wouldn't fall within what you customarily would think about, and we have to explain that and understand what's going on there, and that's what the attempt is with the book.
Mike, why do you call them Grotian Moments? That's a good question.
Okay, so I'm not the first to talk about this concept. Other professors who have spoken about it in law review articles have called it international constitutional moments. And they're using a phrase that comes from Bruce Ackerman, who's a constitutional law professor in the United States, and he used it to describe the huge changes in rapid time of the US constitutional interpretation that came out of the New Deal. And the idea of calling it international constitutional moments might make sense if you're focusing only on changes within a treaty structure. So maybe within the UN Charter, within the EU conventions, within the WTO. When there's a radical change in the interpretation, maybe that's sort of like an international constitutional moment because a treaty can be like a constitution. But when you're talking about things that happen outside of treaties, you can't really use that term. And so I thought Grotian moment, which Richard Falk had coined and used a slightly different way than I'm using it here, is an appropriate way to describe this. Now, most of you know about Grotius. He lived in a very turbulent time during the 70 Years' War and the 30 Years' War. He wrote what became more or less the blueprint for the Peace of Westphalia. And the Peace of Westphalia is usually recognized as a paradigm shift in international law, where the modern international law of the states system grew out of. And therefore, people look at Grotius as sort of a figure whose writings, together with the context, were able to make a huge change, a paradigm shift in international law. And therefore, when you have these fundamental changes in modern times, why not recognize Grotius's contribution and call them Grotian moments? So that's why I do.
Sean, do you agree? Is the Grotian moment a useful, helpful term?
Well, first of all, I'll note that in Sir Michael Wood's first report on customary international law, in footnote 244, he does cite to Michael Scharf seizing the Grotian moment, the Cornell International Law Journal article that was written in 2010, which I think fed into the book. So certainly the ILC is aware of the use of the term and whatnot. I think the problem for me with using that term in this particular context is, the reason why you might say something's a Grotian moment is the idea that when Grotius is sitting there, right, writing his famous book on Law of War and Peace, he basically is seizing an entire period and saying, we now, this period where the Peace of Westphalia is taking place and whatnot, are seeing the rise of the interstate system. We're leaving feudalism away, we're leaving ecclesiastical law away, we're leaving, all this other way of organizing ourselves away, and we're creating now an interstate system, and I can help us in systematizing the rules, right? So it is very much this Bruce Ackerman sort of constitutional moment, major shift, seismic shift. Interestingly, he's not doing a customary international law type analysis, right? He's looking at all kinds of stuff that's not what we would regard as customary international law, because there wasn't a lot of state practice at that point. So he's citing to the Romans and to the Bible and stuff like that. But he is certainly, it's a moment where something has dramatically happened. And when people like Boutros Ghali talk about a Grotian moment in 1995, he's talking about end of the Cold War, seismic shift in the way perhaps international society is going to organize itself, and how that's going to have a cascading effect on a lot of different institutions and rules and whatnot, not just in the custom context, but across the board. And that, I think, is a good way of thinking about a Grotian moment. I'm less persuaded that just a particular change in a particular subject matter area at a particular time in history is properly characterized as Grotian. I mean, you can say that if that's the way you want to use the term, but when you say, look, in this period of time, the thinking about whether you could appropriate the continental shelf changed in a period of 10 years, it's not really a systemic thing, right? It's a change, but it's not like it's unleashing. Now, you could say the post-World War II period was a Grotian moment, right? Rise of the UN, rise of specialized agencies, development of the international capital system, rise of trade law that hadn't been seen before, creation of peacekeeping. You could say that, and that, I think, to me at least, would be a Grotian moment, but the sort of individualized, subject matter oriented, specific things, that's not what I think of as a constitutional moment, as it relates to a particular source of international law. So, no, I guess I'm not entirely convinced that's the best way of talking about it.
Great. Thank you, Sean. Let's go ahead and throw it open to the audience. We have about 20 minutes, 25 minutes for questions before the reception in the hallway. How did you want to handle the mic? Okay, she's got an open mic. Would anyone like to, yes?
My question is to all three of you. Given what's happening in the past 2 years, the Arab Spring and everything, do you think it can be considered as a moment of crystallization of customary international law, where states have an obligation to deal with a post-conflict situation in certain ways, to end the war in just ways?
Yeah. I'm glad you asked that question, and as I alluded before, the two other case studies I looked at were the 1999 NATO intervention into Kosovo and the development of the Responsibility to Protect Doctrine as one, and then the targeted killing of terrorists. Your question, I think, is related to the Responsibility to Protect Doctrine. And I thought this, when I studied this and researched the heck out of it for this book, I found it very interesting because I believe it was almost a Grotian moment. And what basically happened, and it's extremely relevant for what's going on tonight in Syria and what the president is going to say. But what happened in 1999 was that there were atrocities going on in Kosovo. And NATO decided, without Security Council authorization, because the Russians were going to veto it, to go ahead and do a 78-day bombing campaign, which ultimately brought Milosevic to the negotiating table, stopped the atrocities, and led to the current status of Kosovo. Now, at that time, most of the European countries said that they were doing, they talked about it in terms of humanitarian intervention and humanitarian reasons. The US refused to give an actual specific legal rationale. But the Brits, the Dutch, the Canadians, they all went right out on a limb, and they said that's what it was. They said it before the International Court of Justice. And then the Canadians created this organization that developed the Responsibility to Protect Doctrine. And the doctrine was supposed to codify what came out of Kosovo, because as the Secretary General said, we can't have a situation where you have a Rwanda genocide occurring and a country willing to intervene and another country vetoing it on the Security Council and the rest of us sitting with our hands, under our laps. We can't have that situation. We have to evolve to be able to respond appropriately. And so the Responsibility to Protect Doctrine actually spells out the situations where first the Security Council ought to be consulted and they should try to authorize it, but if they're paralyzed, the Responsibility to Protect Doctrine says maybe you should resort to the Uniting for Peace resolution and go to the General Assembly and get a 2/3 vote. And if you can't get that, maybe a coalition should go in and hope to get Security Council blessing after the fact. And maybe if you don't get that, it's still going to be appropriate. And it's a little squishy. And so the next question was, what would happen next? And what happened next, unfortunately, was the US invasion of Iraq and the Russian invasion of South Ossetia in Georgia. In both situations, there was, as one of the justifications, talk about humanitarian reasons. And the international community got very nervous about the potential for abuse of the R2P doctrine. And so finally, the Security Council blessed the doctrine and codified it. And when they did, they squished it back in and they said, responsibility to protect exists as a concept, but it requires Security Council authorization. And what they basically did is they just squashed the blossoming Grotian moment. It didn't occur. Now, even when countries, including the United States, say that the 1999 NATO intervention was sui generis, it wasn't to be taken as a precedent, if it happens again and you have two situations that are similar, it becomes a precedent. And I think we're all listening very closely tonight to see the kinds of language that comes out of President Obama's speech. But if he starts talking about, if you're going to use chemical weapons against 1,400 people and the international community has a responsibility to step in, and if the Security Council blocks it, then countries have to go in and do it, then you've got Kosovo all over again, and arguably you've got some customary international law forming. But I don't think it did form after Kosovo, and I think actually the breaks that occurred at that time are applying now and making it more difficult to get international support for unilateral action outside the UN to save people, stop the atrocities, stop the chemical weapons use in Iraq.
Sean, your take on that question?
Sure. Well, let me say that with respect to the chapter that Michael wrote on this R2P and humanitarian intervention issue, I think it's the best chapter in the book. I think it's extremely well done. I think he's put together a very candid and thoughtful analysis of the way the doctrine emerged and how we might be thinking about it today, and has broken some new ground in terms of teasing out some of the most relevant sources of information. So I highly recommend that. But what I heard, the first words out of the speaker's mouth, what I heard was Arab Spring. And so let me take it in a little bit of a different direction. When the Arab Spring broke out, there was, of course, a lot of hope that this was meaning, a change across the Arab world in terms of ousting governments that were relatively autocratic and replacing them with more democratic governments. And it's a bit disheartening to see that there's been a lot of backsliding in that regard. If you look at Egypt and obviously, Syria nowadays, the protests didn't go so well there, right? And so, it hasn't really gone the direction that maybe you would have thought, but I would place that in the context of the post-Cold War thinking that maybe we were changing in our perceptions of what acceptable governance was, right? So remember, the Cold War ends, and the communist, Soviet Union fragments, and everybody's thinking we're now going to have democratic governments in these new countries. Yugoslavia fragments, we're going to have democratic governments there. And it spawned in the 1990s literature spearheaded by Tom Frank in his first article he wrote on the right to democracy in international law, which then led to books and things. Very interesting concept. Had we reached a certain point where we believe, because of the movement of human rights and everything else, that people were entitled to a democratic government, it was no longer acceptable to have governments that were not democratic in nature. As it's turned out, that hasn't fully caught on, and I don't think it's an easy argument that international law requires, by custom, a democratic government. But the Arab Spring is arguably a little offshoot of that movement, and yet it too has not, ultimately resulted in what I hope Tom Frank was seeing unfolding when he wrote what he wrote. So that's a different way of thinking about the question in terms of perhaps changes in customary international law.
Great. Thank you, Sean. Next question. You got 10 minutes. There's a question over here on the left, and then one in the back.
Good afternoon, Andrew Bell from the Lloyd School. I like the concept. I think it's extremely interesting. I was wondering maybe if you could provide a little bit more precision in our understanding of what's happening in some of these Grotian moments. There seems to be a lot of different things that are going on. In some of them you have, for instance, in the Nuremberg case, it seems to be driven largely by the states of the international system coming together to decide how the new international legal order should play out. And then you look at, say, the Taj case where you have, it's really the international legal institutions up in and of themselves from the top down kind of imposing this new order, or at least crystallizing this new order. So how does our understanding of these different methods of change occurring within the system affect our understanding of these Grotian moments, and how does the influence of international states versus international legal organizations come into play, and does it affect our understanding of whether these Grotian moments are actually successful in the end?
And I think it depends on what you consider to be the state practice in each of the examples. So in the Nuremberg example, you've got an international tribunal that's made out of 4 different countries and their judges. And then you've got the General Assembly endorsing the Nuremberg precedent in a General Assembly resolution that's called a declaration. It's unanimously passed, and afterwards, in the explanation of votes, people refer to it as customary international law, declaratory of new law, and you have the International Law Commission endorsing that concept as well. If you look, for example, at the Tadic decision. So again, you've got an international tribunal that was created this time by the Security Council. It makes a decision that is sort of novel and surprising to everybody, but immediately it's endorsed. And many countries are recognizing it as good law. They're passing laws that are consistent with it. And within 2 years, you've got decisions coming out of international tribunals referring to Tadic. You've got the International Law Commission referring to Tadic as customary international law. And it applies to even countries that haven't acted consistent with Tadic. So, there's actually 2 concepts of how customary international law can be formed. One is that you have to have all the state practice, and then finally you could have a General Assembly resolution that sort of codifies it. And another is that you have a General Assembly resolution or a decision of a tribunal, and then you have to have state practice afterwards that reconfirms it. And either of them, I think, are equally capable of creating customary international law. And what you have in those 2 cases are a mix of the 2 approaches.
Sean?
Well, yeah, I basically agree with that. I guess I would say that the way I think about organizing one's thoughts around customary international law, the classic approach was we're going to look at the state practice in the form of states, issuing statements or going out and doing something physically, and we're going to try to figure out that practice and look for the opinio juris behind it, and that's sort of the way one tends to think about customary international law. And there's some of that going on, but I think that there's three key elements that are now being used to get at that practice, right? So one is treaties, right? When the International Court's deciding the Germany-Italy case, even though there's no treaty between Italy and Germany, the court is looking at the UN Convention on State Immunity. It's looking at the European Convention on State Immunity, not because it's directly binding on the two states, but it's a form of practice. It's some level of evidence for the states that have joined that treaty, how they perceive the proper rule with respect to state immunity, right? So the treaty becomes a surrogate of sorts for what might have otherwise been a rather difficult thing. That's one key element. Another key element, as Michael says, resolutions of international organizations. It's a surrogate, right? If you get 193 states standing up in the General Assembly all saying state-sponsored torture is unlawful, right? Well, that's a pretty important, feature of state practice. You don't need to go to the Botswana Foreign Ministry's Public Affairs Office now to get the statement, which might be rather hard to work your way to. You've got the, representative in New York standing there and voting, or sitting there as its consensus, whatever it is. And then the third key element, I think, are these international courts and tribunals. They really have exploded, right, in the past 20, 30 years in terms of the numbers of them and the subject matter areas they're covering and whatnot. And take something like the Tadic decision, right? We now have international criminal tribunals out there issuing decisions about what they think customary international law is, right? And when they do that, it may be they're just interpreting their own little statute, but maybe that statute's saying apply customary international law. So when they do it, now suddenly you have an authoritative voice that's given some level of attention to what's the practice that's out there among states, and it has this huge effect then on the way we think about customary international law. So I think you could actually take Michael's case studies and possibly reorganize them a little bit based on where were treaties dominant, where were international organizations dominant, where were courts or tribunals dominant. There's a lot of crossover where all of these things are being used, but sometimes some of those elements are more important than others.
And I want to add one thing. One of the surprising insights here is that every time you had one of these major changes in customary international law that occurred very quickly, there was a custom pioneer, whether it be a state, an organization, or a tribunal. And in each time they claimed that they weren't creating new law. And they knew they were. And I definitively proved they knew they were. But what they're basically doing is, and you used this phrase before, they're putting a new vintage in old bottles. And they're trying to do that so it's palatable, so that it can become custom and that no one will reject it. But they know that they're making a radical change. And there isn't an example I can come up with where there's a radical change and a country didn't do this. And I believe, and I have a lot of interesting documents in here that indicate that the countries knew what they were doing. They knew that they were changing the law, but they self-consciously said, let's say that we're not. And that's just a fascinating part of these changes in custom.
I'm shocked and amazed. Let's take Edwin has a question, and then there's one in the back as well. Why don't we take them one here? We'll take all three together. We have 5 minutes then for the answers. So Edwin, Heather, right behind you. Yep. And then there's the back row up there.
I would just like to hear from Michael discuss the sixth case that he has described.
And Heather, why don't you take it to the back? Back right. There's a hand up. Right there.
Hi, my name is Doretta Naples-Mitchell. I'm currently at DOJ as a paralegal, aspiring law student. My question is about the role of the UN special procedures in advancing customary international law. There's some of the most cutting-edge work in a number of fields, from targeted killing to the right to housing, is being done by these independent monitoring mechanisms who are like a combination of monitoring mechanism and mobile international law scholars. So I'm just wondering if you kind of conceptualized or considered their role at all in this process. I think they're often overlooked in the world of tribunals and courts.
Great. And now, Heather, will you bring the microphone up here, tucked in the corner?
I can talk really loud. Actually, my question is the same as the first gentleman. Your targeted terrorists, the killing of terrorists, why that doesn't fit, and then a little soon to decide based on your model and the examples you've given before that it maybe doesn't fit.
Okay, great. We have 4 minutes. So Michael and Sean, I'll let you guys take those questions as you see.
I could be flip and say read the book, and that guarantee that you would, but
This
no,
is my
I'll
panel,
give
you can't do that.
This is Edwin, and I would never do this to him because he was my mentor as well. No, the answer is this. In the early days of the jurisprudence of the International Court of Justice, following the advent of the UN Charter, the ICJ in the Nicaragua case and other cases made it absolutely clear that if one country is going to invade another country and claim self-defense, and it's doing so because of insurgents or terrorists or armed groups in another country, they have to prove that there is attribution of the acts of those insurgents to the government, because you are invading the country, the government's country. And after 9/11, you really had the possibility of a paradigm shift. The international community all got together and realized that there's a new kind of terrorism in town, super well funded by millionaires, using high technology to coordinate, the possibility of weapons of mass destruction worldwide, using suicide bombers. I mean, this was new, and we all had to get together and figure out how to deal with it. And so in that context, we started to target the terrorists in other countries. The United States could have made a really good argument that this was, like by analogy, to neutrality. In the law of neutrality, if a neutral country allows the enemy to put its troops in its territory and target the other countries, then the other countries are allowed to target the enemy. Not the country itself, but the enemy that's within the country. And that's really what we're doing here. If we say the country is unable or unwilling to control the terrorists, we're not targeting the country itself, we're targeting the terrorists. And that, I think, would have flown. The problem here was the rhetoric that we chose in the moment. And this is the Bush Doctrine. We didn't say that initially. We said, you're either with us or against us. And if you are with the terrorists, we're going to attack you. Not just the terrorists, but you. And that was overbroad. And I think that because of that, there was pushback in the form of 2 International Court of Justice cases, the Wall case and the Rwanda-Congo case, in which the ICJ said after 9/11 and after we started doing the targeted killing, no, you still need attribution. And you have 3 strong dissents by some of the best members of the court saying to the other judges, are you crazy? The world has changed. We need to have a doctrine that applies to the terrorists, and you are reaffirming the old doctrine. And so I think right now the law is a bit unsettled, so you couldn't call it a clear case of a Grotian moment. I believe, however, that the law is moving in the direction of recognizing that you can target, kill terrorists in another country under certain limited circumstances, but not the Bush Doctrine. And it is another one of the insights here is when you're going to articulate a new doctrine, you got to make sure it's not scary and that the other countries in the world think it's going to be easily abused, because that will actually keep the Grotian moment from forming.
Sean, you have the last word.
Well, just on the question of, what kinds of, institutions or bodies might be relevant for doing a customary international law analysis, I think the conventional doctrine would, first of all, be when we're talking about what state practice is, we are interested in the state itself and its organs and whatnot, and private actors are not that, NGOs and whatever are not that. The NGO might be doing a report that's talking about the state, and that's going to be helpful in understanding the state practice, but the NGO and private actors generally would not be regarded. With respect to international organizations, again, if what the IO is doing can be characterized in a way that you think it's genuinely helping reflect state practice, then I think it's going to have some probative value. And so, of course, General Assembly resolutions is something everybody grabs a hold of because it's a body of all member states, of the UN, speaking to all sorts of different issues, right? But if what you're suggesting is, well, how far down in the pecking order can we go? You know, would sub-entities that are just, you know, particular groups or particular, you know, regional, sub-regional, special rapporteurs of one kind or another is making a statement of some sort, that's certainly not in and of itself going to be viewed as state practice. If the body, whatever it is doing some very comprehensive study of what states are up to, that may generate some value in knowing what the state practice is, but it in and of itself will not be viewed as such. And I don't think it should be. I think, you know, that at some point you're detaching from customary international law what states are really up to. And once you do that, you run the risk that the law is not going to be perceived as acceptable and that states simply aren't going to conform to it. So I don't think that's a direction that we are or should be going.
Great. Well, please join me in thanking Sean and Michael.